steward of stealing from him. And the steward went away and said, I think my master is going to fire me. So before he fires me, I'm going to go to our trading partners and I am going to ingratiate myself to them. And I'm going to tell them that I will discount what they owe my master, so that when my master fires me, these people or one of them will hire me. Now, this is very interesting parable because on the one hand, the owner commends the steward because he finds out about it, and he commends the steward because the steward obviously acted shrewdly. But on the other hand, the owner was not happy with what he did because the steward was dishonest. And so he fired the steward. Now, I think that the parable illustrates the fact that we should show judgment. We must be astute. We must be sharp-witted and clever and observant and be wise in our management of God's property. But at the same time, we must be honest, right? Because the property is not ours. It belongs to someone else. And so we have to protect it and invest it and deal with it for the benefit of the owner. It's important for us to remember this when we are dealing with God's property. So that's the first step, understanding that we are stewards of God's property. The next is to seek and obtain guidance on how to deal with the property that He has entrusted to us, so we can engender a culture of saving and investment and avoid unnecessary indebtedness that stems from the keeping up with the Joneses type expenditure, which has no redeeming value that some of us engage in. So the reason why we're here today, of course, is for the guidance and the knowledge that the experts that I've invited to speak with us will be imparting to us this evening. So this evening we have three outstanding professionals, Shannelle, Bethel, Claudia, Thompson, and Cleora, Farquharson. I'm going to say a little bit more about each of them just before they speak, but they're going to impart some invaluable estate planning information to us this evening that I think we all need. So first up is Shannelle Bethel, and Shannelle is a lawyer, and Shannelle is going to focus on wills as an estate planning tool. Shannelle is a lawyer of just about 20 years at the Bahamas Bar, and she is the founder of Mitre Court, a boutique commercial law firm centered on the new generation client, as she puts it, requiring swift to the point, firmly based legal analysis and results. And over the past 19 years, Shannelle has developed a robust reputation and practice in the area of real estate and estate planning. She represents a full range of clients and has extensive experience in acting in real estate acquisitions and sales, transactions, financings for lenders and borrowers, mortgagee for sales, and commercial lease negotiation and drafting for landlords and tenants. She has also acted for numerous developers of condominiums and gated community projects in New Providence and has assisted with establishing a number of subdivision developments by procuring the necessary government approvals and preparing governing documentation. In the area of wills and administration of estates, Shannelle provides succession planning advice for business owners and individuals, including all aspects of estate planning, from wills, wealth preservation, and business continuity to estate administration and probate applications. So you'll see from that, Shannelle is well-equipped and skilled and to speak to us this evening. I'm very happy that Shannelle consented to speak to us, and I'm looking forward to hearing her presentation. I'm going to ask that any questions that you have, we can save them for the end so that we can get through all three presentations, and you can either make say your question at the end or put it in the chat, and we'll make sure that it's brought to the attention of the relevant presenter. So without any further ado, I'm going to ask Shannelle now to begin her presentation.
Thank you, Tanya. Thank you, Tanya, for that warm introduction. Good afternoon to everyone and happy International Women's Day. Bear with me a little. My mic sometimes it seems to be dropping from time to time on its own. I'm not sure why, but if I do fall out, I'm kind of paying attention to that as well to make sure that I get it back up, that in the video. Yes, so we're talking about estate planning this evening, and you know, what a topic to have to talk about, because, you know, as Bahamians, we generally, you know, we don't like to make wills because some of us are, you know, we think as soon as we do this will, then that's it. But, you know, I'm finding that more and more with presentations such as this, and with the internet and with technology, people are understanding that, you know, it's just so important to ensure that after you pass away, the persons who you want to get access and to benefit from your assets actually receive them. And the best way, while the law does provide in legislation for how that can happen in the event that you do not provide it for yourself, it's always good for you to take that proactive step, as Tanya has indicated, because we are only stewards of our assets. And those assets should be for generational purposes, so that our family members, our friends, our churches, and the causes that we hold dear to us can also benefit. And so the greatest way to do that after your death is to, while you're alive, make sure that you have a will in place. So I'm going to spend a little bit of time on some of the formalities, one of which is obviously that you need to be over the age of 18, and also that you need to be of sound mind. Some people believe that that means you can't be crazy, but it really is a bit of a more technical meaning. And sound mind, one of the key things that are important in establishing that as well, especially if you run into estate litigation, your estate runs into litigation after death, is, do you understand really the extent of your assets and the people who ought to benefit? Because if you don't, and you leave your will in such a way that it appears odd, there's a possibility that it could be set aside, because it can be established in a court of law that why would you disinherit certain persons, or why would you not make provision for certain assets? So sound mind really relates to more than just not being mentally stable or having some other overriding disease that may be affecting the mind at the time of you preparing and executing your will. One of the other items is obviously that you need to be executing that will in the presence of two witnesses. Those witnesses should be present with you while you sign that documentation, and that's crucial. And the witness affidavits that would be attached to that will would obviously state that they in fact were present, and that witness affidavit is notarized so that there's some veracity to that sworn statement. The will tell the world, or tell those persons who now have the responsibility to probate your estate, that I would like my home to go to my children. It will tell them how that home is to be divided, whether it's to be to them as joint tenants, whether it's to be to them as tenants in common. It will also instruct who that person is. So when you're executing your will, you want to think, who is the person that I would like to be responsible for administering my estate? And that's a very important question. And I would venture to say even more so important when you are dealing with a situation where your will is being done while you have minor children. You want to really give thought to the persons that you are appointing, whether that person or persons have the necessary financial acumen, whether they share the same values that you share, and whether or not, from a familial standpoint in terms of your children, whether that person is the best person to understand the type of upbringing that you would like for your children to have if you were not here. And so that's a very important consideration, especially with minor children, as well as ensuring that you utilize the advantage of being able to state in your will who you would wish to be a guardian of your children in the event of your passing, because that does in fact have quite a bit of weight when you're probating the estate. Now, when you are deciding on, for example, leaving these assets to children, one of the things that is very important to remember is that if you have children that are dependents, you need to make sure that you make adequate provision for children that are in fact dependents. And I say that in the sense that you may have a child that is, and loosely, you may have a child that's over the age of 18, but is still dependent on you financially for the purposes of education, for example, or in fact dependent on you because they may have some operating disability, whether that's disability of the mind, disability of the body that requires you to assist with their everyday upkeep, maintenance, and care. And if you have such a situation and you disinherit that child or you don't make adequate provision for that child, the court can reapportion assets in your will to make sure that that child is adequately provided for. So you need to address your mind to those types of considerations as well. Another is as a spouse, as it relates to your home, the matrimonial home that you reside in at the time of the death of a spouse. That surviving spouse has an overriding right of occupation in that matrimonial home, and that operates notwithstanding that you may have left that home to someone else. And that really applies where the husband and wife are not joint tenants. The laws of survivorship don't apply, because with joint tenancy, as soon as one spouse dies, the other automatically is the sole owner of the property without having to go through any probate process. So that would not necessarily arise. But if, for example, one spouse owns that home and they live there and that spouse dies and purports to leave that home to someone else, the surviving spouse cannot be put out of occupation of the home. And they, in fact, have a right to appropriate any interest in the home that may have been left to someone else for fair market value. And there's information in the legislation that can point you in the right direction if you find yourself in that situation, whereby you can make sure that you still have a home during your lifetime. So that, it's a very, and I'll tell you, it's a very funny area of law, because obviously the parts that are most poignant are when you have outside children. Our laws no longer make a distinction between what we used to call inside children or legitimate children and children born out of wedlock, referred to as illegitimate children. That is gone. And so sometimes, because there are outside children, there are children of the marriage, and the will does not, and the will leaves this home to all of the children jointly. This creates an issue for a surviving spouse, and sometimes, and the outside children sometimes. So the law has made sure that there's provision made for that surviving spouse. Now, let's talk about insurance policies, because those seem to sometimes be a bit of a technical point. When you're leaving something to someone, proceeds of an insurance policy in your will, what you need to do is you need to ensure that you've also already made the adjustment on your insurance policy. Because if you pass away and that insurance policy has a named beneficiary, the insurance proceeds will go to the named beneficiary. It will not go in accordance with your will. And that can cause some problems in the event that you have that type of inconsistency. So if you do have a policy and you wish for it to go in accordance with the provisions in your will, then the suggestion would be to make the change on your policy to state estate, and then in your will to make sure that you apportion those proceeds as you see fit. In the event that there are beneficiaries already named on that policy that may have some right to consent, like a spouse, or in some instances, children, then you would need to get consent from those children given to the insurance company to ensure that you can change the named beneficiaries that are on that policy. And I'm going to talk a little bit about when you move into that probate process, because when you do have a will, one of the best features of that will is that there's a named person that has the power to deal with your assets. And that person has that power from the date of death. The minute that you pass away, they are immediately by law empowered to do certain things. When you don't have a will, that's not the case. The law sets out what happens on what we call intestacy, when you pass away without a will. And they say, here is the list of priority of persons who have a right to go to the probate court to request that a grant be issued in their favor after you have produced a number of documents that set out who are the persons entitled, as well as who are the persons entitled to assets. But with a will, you're empowered right away. So if Shannelle Bethel is named as the executor, there's certain things I can do. I can take possession of property, I can take possession of assets, I can get certain information from entities just by virtue of having been named the executor in that will. I can also make certain types of applications on the basis of urgency before the court. For example, if the deceased person has a ongoing business, that ongoing business may in fact be crucial to have someone in a position of authority in order to continue to run that business, that cannot wait 2 or 3 or 4 or 6 months in order for the estate to be probated. So that's another feature. You may have minor children and you need to get access to certain types of assets in order, or sign certain documentation to ensure that their life continues smoothly during that transition. And as an executor, you can do that, but not if there's no will in place. And so that goes to show that it's a very responsible thing to have that executor named and to have that will, and to be clear and to reduce confusion in the event of your passing, so that there isn't a lot of animosity, unfortunately, that that comes about, and because of disagreements on how things ought to be done, because there's a piece of paper that clearly says what you would have wanted as a deceased person. In addition to that, as Tanya stated, you can make gifts to causes and to churches, and it's important to make sure that you do support those causes that are close to you. When doing so, what you want to keep in mind is how that is referred to. So you want to make sure that you seek appropriate advice when you're having your will drafted, because there are certain nuances in law that talk about if you leave something to a particular charity and by the time you pass away, that charity no longer exists, you don't want your gift to lapse. You want to ensure that the wording of those clauses are drafted in a way that it carries over, or if there's a certain asset that was meant to go to a particular person or to a particular entity, and those assets are converted for some reason during your lifetime into another type of asset, you want to make sure that, and then when I say that, I'll give an example. For example, in the event that you own shares that are then later liquidated, and so at the time of your death is cash, you want to make sure that it's worded in a way that that cash still gets to the entity or the person that you would have intended for it to get to. We want to make sure that you do not have witnesses to your will that are also beneficiaries. So if you're getting a gift under the will, you cannot have that person or that beneficiary to be a witness to your will, because we obviously want to the law wants to make sure that there's no undue duress that went to bear in the drafting of that will. And particularly where you have a person who may be in hospital at the time of execution, or who may have some form of disease that they're operating under that may not affect their mental capacity. I always recommend that in such an instance, you either request that the attending physician for that person be one of the witnesses to the will, so that you can word their affidavit in such a way that it is made clear that that person, notwithstanding whatever disease or deficit that they may have, that is not something that is operating in a way to cause them to make a will which is not a true reflection of what they intended to do. Tanya, how am I doing for time?
Okay, I think you should probably, wrap up.
Yeah. So let's talk a little bit about, I'll wrap up talking just a little bit more about intestacy. So when you don't have that will, in the first instance, your spouse, if you have a spouse and no children, then everything goes to your surviving spouse. If you have a spouse and children, then those assets are split 50% to your spouse and the other 50% is shared equally between your surviving children. In the event that, and those surviving children then have to share those assets accordingly. In the event that you pass and your spouse is no longer alive, or you died without a spouse, but you had children, let's say you had, one of the interesting things is if you had 10 children, I know that probably doesn't happen anymore in modern day life, but you have 10 children. One of the things to bear in mind is that those children have to jointly make that application, but only up to 4 of them can actually be appointed as administrators of that estate. So it means that some will have to consent to the 4 or the 3 or the 1 or the 2 that would make that application and would need to agree. So once again, having children come together and agree on how things would be done, and especially where those children may not have a great relationship, again, is something that you want to bear in mind and have that will, so that you can again reduce any conflict that may come about as a result of that. So in wrapping up, I would generally say that the responsible thing to do is to definitely have a will. Your will can be as simple or as complicated as you would like it to be. But the number one thing we would say is to seek the appropriate legal advice, regardless of how simple you think your will might be, in order to put your affairs in order, so that at any time that untimely time comes when we all must pass away, that those who we have left as the stewards of our assets moving forward can transition through that process appropriately, without much stress. They can reduce and limit the amount of financial expense in relation to your estate, and they too can benefit from the responsible acts that you've taken during your lifetime.
Thank you so much, Shannelle. That was very, very good. And I'm sure that there are going to be a number of questions. I see a hand raised. Terry's hand is raised, but Terry, we're going to have the questions at the end. So just keep your question, please. And we're going to try and get through the presentations first, and then we'll have the questions. This is when it really becomes interesting, because people have their real life questions and concerns, and so we'll have that discussion at the end. So at this time, I'm really pleased to have Miss Claudia Thompson, who is from CFAL, Colina Financial Advisors Limited. She's a pension administrator and client relationship officer. And prior to her life at CFAL, she worked as financial controller of investments at Island Site Development, and as a sales and marketing manager at Machinery and Energy Limited. Mrs. Thompson holds a Bachelor of Science degree in engineering. And to complement her transition to the financial services industry, she completed the Canadian Securities course in 2016 and the Certified International Financial Planner certification in 2021. She is happily married to her high school sweetheart, Mr. Frederick Thompson, and she is passionate about helping others to win their financial freedom through saving and investment. So I'd just like to welcome Claudia. Thank you so much for being here. Really appreciate it. And over to you.
Hi, good evening, everyone. How's everything? And thank you so much, Tanya, for inviting me to do this tonight. Can everyone hear me okay? Can you hear me? Okay,
yes,
great.
we can.
Wonderful. I have a little presentation. It's going to be very, very short, so don't worry. And I will be available for questions afterwards. So Tanya so kindly invited me to talk about saving and investing. So we're going to talk a little bit about budgeting and all of that wonderful, fun stuff, but it's necessary, right? Especially in these kinds of times. Can everybody see the presentation? Okay, great. So we're going to discuss the current economic situation, your financial health, a reality check for you, saving and budgeting. We're going to go through a budget guideline, and CFAL solutions, what's available. And then we can take questions after everybody has spoken at the very end. So the current economic situation, so we all know that COVID-19 brought economies worldwide to a standstill, and the Bahamas is still recovering from Hurricane Dorian and COVID-19. Thank goodness some of the cruise ships are back, and the tourists seem to be very happy to be at Baha Mar, at Atlantis, so that's a very, very good thing. But as at December 2019, the Bahamian economy, the unemployment rate stood at 10.7%, which is quite high. And we are very reliant on tourism, which is 60% of our GDP. And the tourism sector is about 50% of our workforce. In our economy, unfortunately, people tend to live paycheck to paycheck, which means that they don't have savings. They're really just going from one week's pay to the other week or monthly, depending on how they get paid. 90% of bank accounts have less than $10,000. And NIB only offers temporary assistance, as we all know. So your reality check, where are you today? There are 5 questions that we ask you to sit down and ask yourself and your household. How prepared are you for an emergency? COVID-19 and hurricane season. Usually we're prepared somewhat for hurricane season because we're used to preparing every year. But COVID-19, I don't think anybody could have foreseen that. And now with the Ukraine and Russia crisis, I think with the gas prices skyrocketing, we need to keep in mind that we do need to be prepared. How much do you have in your accessible savings? An emergency fund, investments, and savings plan. So an emergency fund, I'm going to talk a little bit about that. That is a little bit different than any type of investments. An emergency fund should be something that you can access in a day's time. So something happens this evening, you can walk in, say to a commercial bank or a credit union, and walk out with funds in order to take care of that emergency. When we talk about investing, we're talking more about long-term, and any type of investment should take maybe a few weeks to maybe a month or 2 to get your funds from that investment house. Also, number 3 is very important. How much debt do you have? And are you able to keep making payments? And what are your main financial struggles? Be honest with yourself and aim to overcome them. So I know everybody has different financial struggles. For me, I love to buy shoes. I know a lot of us love Amazon. We love to do, eating out. We love to travel. So whatever your struggles are, try to budget for them, and we'll show you how to do that. And 5, are you stressed out over your finances? So we know that there are uncertain times ahead, and the temptation can be there to just, bury your head in the sand, throw the bills, the envelopes in a drawer and try to forget about it. But believe me, they don't go away. So we say try to face it and write it down and get help with a financial services provider if you can. So this is just a basic template that we use. I've had clients come to me with, complicated spreadsheets and, all these charts and graphs. And we say, okay, we're going to break this down as really, really simple. Just write down what is your income every month and what are your expenses every month, and track it for 6 months. And then you'll have a budget. And they just look at me with a blank stare, but it really is that simple. Yes, you can get complicated and try to put things in different software and go from there, but the old-fashioned way is also very effective, and just writing down how much comes in versus how much goes out. So we ask you also to review your financial picture every year. Take time to reflect on your reality. For a lot of us, that has changed. It changes every year, sometimes every 6 months. So take a look at that and see what is going on with you. Revise your budget if you need to. Cut out non-essential spending. Contact your lenders to reduce debt. If you are in any problems with debt, it is always best to communicate with your lenders and try to work through a plan with them. Just hiding away and not answering their calls makes things worse. So always try to go in and sit down and communicate with them and try to work out a payment plan. Contact your utility companies for your monthly bills, those sorts of things. You also should do and work out a payment plan if possible. Create a budget. So set a budget. The next thing is to save ambitiously, how to manage debt, we're going to talk about, and then to give back and who to give back to. So a lot of clients use this as a budget template. 60% of your income should go towards what we call necessities or bills: rent, mortgage, food, school fees, car payments, clothing, insurance, anything that you need to keep paying for in order to live comfortably. You can reduce these to get these within the 60% range. If they are over your 60% of your income, you would need to look at these as a way to reduce your bills. 5% should always be going to your pension or retirement savings. And as you get older, this 5% should go up even higher. Anytime you're over 40, you should increase your pension contribution at least 1% each year. So the closer you are to retirement, the more you should be saving. 10% in regular savings. This is your emergency fund that you build up first, and then you go to investment and other types of savings with this 10%. 10% should be to your charity or church, and then 15% is enjoyment and luxuries. So everybody loves this 15%. And yes, this is where we have our travel budget. This is where we have our eating out budget. Believe it or not, eating out is a luxury, not a necessity, even though that's one of the things I love to do personally. But the idea is to budget for it accordingly. And a lot of clients come in and say, oh, but this is necessary. This is a bill. And I'm like, no, this is an enjoyment or a luxury. So the difference is, say, for instance, you want a Coach or a Dooney & Bourke purse. Yes, that would go under enjoyment or luxuries, because a Target purse could do, and yes, you do need a purse, but it can go under bills as a cheaper purse from Target or Walmart versus an enjoyment or a luxury bag in that Michael Kors or Dooney & Bourke price range. So just a quick example there. Save ambitiously. So start an emergency fund. I don't know if any of you have heard of Dave Ramsey. He always talks about starting with $1,000 as your emergency fund, just in case, you know, you have medical bills or car repairs or anything that's unexpected, you have that cash available. And then go ahead and start saving and building that up to 3 to 6 months worth of your living expenses. Then save 10% of your salary for retirement, if you can increase that 5% up to 10%. And other saving and investment goals, and always save more if you can. Learn about investing. So which options are right for you? Mutual funds. CFL specializes in these. We have a CFL bond fund that you can start with $1,000 or more and invest in. And the interest rate is around 4.25% each year. And a lot of clients like this because it's a low risk fund. It's invested in government bonds and local corporate bonds. We also have access to government bonds. Some of you might have gotten a notice from central bank talking about, you know, if you have bought bonds through them, now you have to go through a registered broker trader, which is what CFAL is. So you may want to talk to someone in our brokerage department about that. But government bonds are also a traditional way of low risk investing. Stocks are when you buy shares in a company, you become an owner in that company. And if the company does well, you get dividends. And if the company does not do well, you do not see a return and your share price may go down. So the idea is to gain growth from the share price as well as dividends if the company does well out of the profits of the company. So stocks mean ownership, and they are usually more volatile than any type of mutual fund, government bond, or corporate bond. And then real estate. This is a really good one for Bahamians. A lot of people, excuse me, have made a lot of money through commercial rentals and residential rentals. And a lot of retirees enjoy doing this because they have their apartments on rent and they take care of them and they earn their income through that. And they found it very profitable. Real estate generally appreciates over time. So this has been a traditional way of growing your wealth. So why have an emergency fund for unexpected event like a hurricane or global pandemic? You know, we always say have something for a rainy day. Our grandparents always would talk about that also. And we have seen that live out in the last 2 years. We couldn't have imagined the hurricane in Abaco. We couldn't have imagined COVID-19. So we really have seen that an emergency fund is a necessity now. It allows you to bounce back quickly. You'll have funds set aside to pay for unexpected items. It avoids you going into debt or trying to get a loan with unfavorable terms, and it provides you with peace of mind. So how disaster may affect your finances? It affects the cost of meeting immediate needs. We know food and medical bills, the cost to repair and replace items if something happens to your car or home appliances. The cost of your monthly bills doesn't usually go away. Fraud, I know in the beginning of the pandemic, a lot of people were using their credit cards and had, fraudulent charges put on them, and they had to go to the bank and get new credit cards. It was a very big hassle, so keep that in mind as well. And the cost of missing any payments. If you lose your job during any sort of pandemic or economic downturn, you tend to miss payments like mortgage payments, utility bills, but it's best to talk to your lender and let them know your situation and try to work something out with them to avoid any late fees if possible. If you're still working, try to revisit your budget every year. Some things are automatically cut, obviously due to COVID-19. A lot of people have stopped traveling, and so you're able to save more if you're still working. Supplement your income, find other creative ways to make money. The average millionaire has 7 different sources of income. So always be thinking of different ideas and different ways to make money. Personal development. You can develop your skills via online courses and update your resume. A great thing for this pandemic was that you were able to attend school, online. You didn't have to leave the comfort of your home, and you had access to lecturers all over the world. This is a big one, debt management. So if you are overburdened with debt, should you invest or reduce debt? We always say reduce debt first, because chances are the interest rate that you are paying on your debt. So say credit card debt is about 22%. Any type of investment, say if you did the CFAL bond fund and you're getting 4.25 in a low risk investment, you're making 4.25, but you're paying 22% on that credit card debt. So it's always better to go ahead and pay off that credit card debt so that you get rid of that 22% interest rate. Always pay off your higher rates of interest first. So always pay off your credit cards, your consumer loans. Sometimes car loans are like 13%. Home improvement loans can carry that type of interest rate. Your mortgage rate should be low. You can renegotiate now, sometimes down to like 4.95%. in some cases. So always try to renegotiate your mortgage as low as possible, see what the going rates are. And then debt consolidation. We've had clients come in and show us proposals from banks. Yes, it can be the right choice for some clients, but a lot of times it extends your payments for much longer and you end up paying more interest over that period of time. So always read the fine print if you're going to go the debt consolidation route. Give back. So should I give when my resources are so limited, and who should I give to? What I usually say is try to put the mask on yourself first. Like in the airplane, the stewardess always tells you, put the mask on yourself first and then be a blessing to others. So make sure that your financial house is in order, and then by all means, be a blessing to others. Just gonna touch on two of our products briefly. The CFAL Savings Express. This is a very popular product. It gets you into the habit of saving. You can start with as little as $100 and put $25 per month. It's locked in for 2 years. And after the 2 years, you can withdraw twice per year with no fees. There is an interest rate of between 2.5% and 3%. It's invested in our money market mutual fund, which is certificates of deposits and government bonds, very, very low risk. So this is very popular with people who are saving for a particular goal, say a down payment for a home, a new car, school fees, that sort of thing. A lot of clients use this Savings Express plan for short-term investment or savings purposes. We also have a CFAL Blue Marlin retirement plan. A lot of entrepreneurs love this plan because they have an individual option. It's locked in until age 65, but you can start with as low as $50 and you can put $50 per month. It's managed by a board of trustees, so you really are locked in until you show proof of retirement or you reach age 65. And you have a choice of 3 mutual funds with us, ranging from low risk to moderate risk. And interest rates are usually between 4.5% per year. And this is really a great plan. We have clients who have transferred existing pension plans from employers into this to make sure that they don't touch the funds until they need them at retirement. So just in wrapping up, we ask you to take control of your budget and make room for saving. Start your emergency fund as soon as possible, and then speak to an investment professional if you feel overwhelmed. We are here to help. So thank you so much for your attention. I will be available for questions at the end.
Thank you so much, Claudia. Really appreciate that. That was a lot of very good information. And I'm sure I've already received a couple of questions, so I know that there are going to be some questions at the end. So at this time, we're going to have our third and final presentation, and this is coming from Cleora Farquharson. And Cleora Farquharson has presented for Centerville Church before, and so I'm very pleased that she's here again. She has over 20 years of experience working in both the public and private sectors of the financial services industry, and her area of expertise includes portfolio management, corporate finance, and business development. She's currently the VP of Pensions Management at Royal Fidelity Bank and Trust. And in this role, she's responsible for direct oversight of the department, which includes management of all client relations, marketing, and all compliance issues. Presently, the company's pension portfolio is valued at more than $250 million. In terms of professional qualifications, Ms. Farquharson has an associate's degree with concentration in finance from the College of the Bahamas, a Bachelor of Commerce degree in finance from St. Mary's University, Halifax in Canada. And additionally, she has successfully completed the Canadian Securities course and level 1 of the Chartered Financial Analyst program. She is also a chartered investment manager and an associate of the Bahamas Institute of Financial Services. So I'm really happy, Cleora, that you're here with us this evening, and I'm also looking forward to your presentation. So over to you. Thank you so much.
Good night, everyone. And thank you, Tanya, for that kind introduction. And welcome to everyone, and especially the women on this International Women's Day. So I'm just going to talk to you briefly. I know it's late, but I just want to give you some information on retirement, some of the realities, what kind of funding you need to enjoy your retirement, and then just answer any questions or concerns that you might have at the end. So at some point, you're going to be retiring. You're about to retire, you're going to retire soon. The presentation today is just really general information on retirement planning. The best solution really is to meet one-on-one with an advisor. So one of the first things we do about retirement, and I have a lot of persons that come to me and they say they're ready to retire, but a lot of persons do not think about what it is that they want to do for retirement. And what's even more concerning is they don't think about how much they actually need to retire. A successful retirement requires smart planning and strategic investing. So it begins with envisioning a rewarding, healthy, and responsible lifestyle. Your retirement may include traveling to far-flung destinations, indulging in your favorite hobbies, and enjoying unhurried time with friends and family, devoting more time to volunteering, or even just starting your own business. But the key is, if you want to make it a success, if you want to make it happen, you have to plan, and you have to plan sooner rather than later. So when it does come to retirement, there are some challenges that we have to look at. And some of the realities are we're living longer. So that means that your retirement monies have to last longer. There's a growing focus on health and fitness. You have to think about the availability of medical care. One thing that you have to think about when you retire is factor in the cost of insurance, because medical insurance is very expensive. One thing my clients do and they forget to do is when they plan for retirement, they forget that, when the employer usually pays for half. And when they do retire, they don't factor in the fact that they would have to cover that full cost of retirement. And with retirement, your income is fixed. So you want to be able to minimize as much, as much cost as you can, but always factor in insurance, medical insurance, because it's going to eat up a lot of your retirement funds, but you need it. Ongoing scientific advance, like I said, is going to aid with you living longer, and meaning that your money has to last longer. And retirees are living longer than 20 years more into retirement. And we can't forget about inflation, because it's also going to affect your purchasing power in retirement. One of the things we need to focus on tonight too, especially with being International Women's Day, is women in retirement have to think about certain challenges and realities that affect their retirement. First and foremost, women are making less. Women make less than their male counterpart. It's just a fact. It might have to do with the job description that you have, but a large component of it is the wage gap. Women on average make about 79 cents to the dollar male counterpart, and that's according to the US Census. Women spend less time in the workforce, and that's because they are, spend time rearing kids or taking care of elderly parents. So it's estimated on average that women spend about 12 years less in the paid workforce than men. Also, too, women generally live longer. It's not a bad thing, but what that means is, women tend to live around about 80 years old, men 75. So that's additional 5 or so more years that they have to fund their retirement, and not forgetting the fact that they spend less time in the workforce because they're rearing kids or taking care of parents. And on top of that, they are making less. So it's very, very important that women focus, especially on, having enough finances to cover their retirement. So one of the things, like I said, a lot of persons raise their hands and they tell me, oh, I'm going to stop working at 60, 65. But a lot of Bahamians cannot tell me exactly how much you need. Experts say, and we support the fact that you need to have about 70 to 80% of your pre-retirement income to live comfortably post-retirement. That's provided you don't have debt. A lot of Bahamians go into retirement with kids in college or a mortgage. If you find yourself in that position, as opposed to needing 70 to 80%, you're going to need about 100 to 120%. And of course, all of that, those numbers are going to fluctuate based on what it is you're going to do. If you're going to spend a lot of time traveling, you're going to need more. If you're going to downsize your home, you're going to need less. If you have sickness, Bahamians tend to have high blood pressure, kidney disease. So medical expenses are very high in that regard. But the idea is you have to think about your retirement and then factor in such costs. So what this chart is showing you is just to give you some idea of exactly how much you're going to need for retirement. So what this chart is showing you is somebody making $300 a week, an annual pay of about just under $15,000. And what I tell persons is you're not going to die of, having said at 60 or 65, you're going to live 20 or so odd years in retirement. And when you think about a gross rate of investment rate of 5%, inflation is going to eat up about 3% of that. So you're only looking at a net rate of about 2%. When you stop working, you're supposed to have somewhere about $350,000. At $400 a week, or just under $20,000 a year, when you stop working, about $470,000. At $50,000 a year, you're making $50,000 a year, you're going to need about $820,000 stored up at retirement. And at $60,000, you're going to need about $982,000. If you have longevity in your family, so you're going to live 30 years as opposed to 20 years, as opposed to needing about $982,000, it's going to go over $1 million+. And these are real numbers. And what I like to tell persons is the only thing that stops in retirement is your salary. You still got to eat. You still have to pay bills, etc. So invariably, what's supposed to happen is while you're working, you need to be putting away monies to save almost for another lifetime, because 20 or 30 years is a lifetime. So, it's unfortunate in the country that we don't have legislation for pension to make it mandatory. But in absence of that, we need to be taking care of our financial futures and make the sacrifices for your betterment in retirement. So in terms of where this money is supposed to come from, primarily 3 sources. Personal savings is supposed to account for about 65% of that. But if you think about it, according to central bank statistics, less than 1/3 of all Bahamians have more than $1,000 in their bank account. NIB is supposed to only account for 15% of that total. But a lot of Bahamians are under the mistake that they're going to roll up to National Insurance Board in Blue Hill Road at 65 and collect a check for $2,000 or $3,000 or $5,000 to $6,000 a month. National insurance, when it was created back in 1974, was never supposed to be your primary source of income. It was only supposed to be a supplement source. And the way that it operates, national insurance does not create wealth. All it does is transfers wealth from one generation to the next. So back in the day, you had families having 7 or 8 kids. Now most families are having 2 and 3 kids. So it's less people paying into the fund, but people are living longer. So, according to their own estimates, it's going to be depleted by 2029 intermediate scenario. Then when you look at the fact that your employer-sponsored plan, if you're fortunate, because like I mentioned, it's not mandatory in this country, and there's so many employers that do not provide a pension plan for their employees. So you have people working on jobs for 30, 40 years, and they retire with a watch, a gift, etc. So in the absence of legislation, as opposed to 65% coming from your personal savings, it ends up being almost 85%. So, but at the end of the day, what I always like to tell persons is you need to be responsible for your own retirement. Make the sacrifices today for a better retirement tomorrow. So you need a plan. And one thing persons always tell me about, planning for their retirement is, where am I supposed to find the money? So I always, encourage persons you have to reduce your expenses. And we like to live vicariously. We like to worry about what our neighbors are doing, etc. But if you want to plan, if you want to reach your financial goals, in particular retirement, you need to make the sacrifice today. And as the former speaker said, you need to budget. Budget is key. Budgeting makes you disciplined in terms of your finances. I tell persons, stop borrowing. You're not walking past the bank and you're pulled in. You put on all your clothes, you make the appointments, you go to the banks, you get these loans, and then you mad with everyone when you can't pay the retirement bills. I'm sorry, the payments. Avoid those numbers houses, pay off those credit card balances. You only need one. What persons don't realize is credit cards make a lot of money for you. When you think about a credit card balance of about $1,000, Bahamians tend to just like to pay the minimum of $50 a month. When you think about a credit card that's it's charging you 17%, and you have a balance of $1,000 and you're only paying the minimum, it's going to cost you almost $2,500 and 17 years to pay back. A $2,500 balance is going to cost you almost $8,000 and 30 years to pay back. And a $5,000 balance is almost going to cost you just under $17,000 and 40 years to pay back. So pay off those credit cards. You only keep one. Start using a debit card. Brown bag it several times a week. I work downtown. Lunch could be as much as $15 a day. Shop for generic brands. There's nothing wrong with Just Bleach versus Clorox. Limit those entertainment expenses. Dinner could be very expensive. Opt for basic cable packages. Right now I use a Fire Stick. Going out to watch movies is very expensive. You can always find ways to reduce your expenses. Seek lower rates on credit cards and mortgages, and always live within or below your means. And just to give you a little quick example of what you can save. So for instance, this is considering a 22-day month. You have lunch, you're charging, like I said 50, this is just saying being conservative with $8. You're going to save almost $176 a month if you stop eating out. Coffee, we love to go to Starbucks, these Frappuccinos, these expensive, funny name drinks. If you stop doing that for a month, that's $6 a day. That's $132 a month that you can save. Soft drinks, there's $1 a day. Clearly, this is taken in VAT. That's $22 a month that you can save. A night out, we spend about $150 just going up for a night, having a good time. If you do that, you stop doing that twice a month, you can save almost $300. And that's going to give you a value of about $630 a month just by cutting back on certain things. And then what we do with those expenses, we cut those expenses, we identify savings, and then what we do is we make this money work for you, right? What this chart is showing you is you're going to put $100 a month to age 65. And, like I said, the sad thing about retirement planning, especially, it's not high on the agenda for person saving. So retirement is, people think about retirement after they've done all of their major goals, and they start thinking about retirement later in life. And this is a mistake. When you think about retirement, remember those figures that I called off in the first set of slides. you need anywhere from $500,000 to $1 million plus to maintain your current lifestyle if you want to maintain that lifestyle in retirement. If you start at $100 at age 20, considering a conservative portfolio paying about 6%, at age 65, you can save almost $200,000. At 8% portfolio, $350,000. And at 10%, you can save almost $632,000. The problem, like I said, with a lot of Bahamians is they wait until they're later in life to start saving. The same $100, if you wait to start at 40 to 65, it drops from $199 to just under $70,000. At 8%, only about $96,000, and at 10%, about $132,000. If you wait even longer to age 55, it drops even more, just under 17,000 at 6%, 18,000 some at 8%, and then at 10%, about $20,000. I always meet with a lot of clients, and I sit with a lot of them, and it's unfortunate that when they come to me, they're close or in retirement. I had this one lady come to me, and she was not a spender, but what she did in her life in retirement was she was a giver. Family members came to her, school, et cetera, et cetera. But when she actually made her retirement plan, like I said, it was in retirement. And when I showed her the numbers that she's going to need for retirement, she said she wished someone had told me this message while she was working, because she would have done things differently. So tonight you're hearing this message. So I'm hoping that, it's not too late. If you haven't started yet, it's not a problem. We'll find a ways to, budget and cut your expenses, and so we can get you to start saving more. Pass this message on to your children, et cetera, so they can start sooner rather than later, so that when they do retire, they can actually retire comfortably and enjoy their retirement years. And just to sum up again, one thing about retirement is you want to think about what it is that you want to do. You have to have an idea of what it is, and then you have to think about how it's going to cost, how much it's going to cost you. And you're going to think about how it is that you're going to fill that income gap between what it is that you want and how am I going to get there. Then you want to be able to take those funds that you do have and make them work harder for you, and find a great investment product that's going to generate the kind of returns that you're going to need. And always remember that if you have problems and issues managing your funds, thinking about retirement, and you feel lost, always seek the advice of a professional. I will be happy to sit with you, create your budget, and help you on that road to retirement. And thank you so much for your kind attention.
Thank you so much, Cleora. That was very informative and enlightening, and reminds us about how much more we have to do to make sure that we're fully prepared for retirement. So thank you again. I very much enjoyed that presentation as well. Okay, we have a number of questions already for our presenters. The first question I have for Shannelle is, someone asked you to just speak to the whole concept of irrevocable beneficiary, I guess, in the context of insurance and wills. I think you touched on it, but I think they wanted a bit more clarification on what it means to have an irrevocable beneficiary in the context of, or I guess, in relation to a will.
Right. So an irrevocable beneficiary is someone who you have placed on your insurance policy, for example, like a spouse, and you've said that in the event of your passing, Shannelle, Bethel, my wife, is to be the beneficiary of the insurance proceeds. And essentially, it's like a contract. It creates an irrevocable trust, so that the person who has taken out that insurance policy cannot unilaterally go in and say, I'd like to change the beneficiary, or I'd like to change the percentage that I've left to this person. That spouse would then need to attend to the insurance company and execute consent documentation for the purposes of changing percentage shares or changing their name off of that insurance policy. Similarly, you have what we call mutual wills, which has a slightly similar concept in that you can make your will with your spouse at the same time, and you make them on mutual terms. And what that does is it creates a contract with your spouse, which precludes them from being able to unilaterally change that will, unless you have joined in and consented to the change in that will. And there've been cases where the courts have found that a will that was changed after a mutual wills have been executed between spouses, if they find that it does amount to a contract, the later will would not be recognized, and they would recognize the will that would be considered a contractual will done at the time both spouses executed them.
Okay, thank you very much for that answer. Yeah, they have to, if you're going to do a mutual will, be very, very careful about executing a mutual will, because you'll be tied into it. I generally advise that each person does their own separate will without contracting with another party to be tied to a particular will. Another question, Shannelle, that came in early on. Actually, Terry Antonio had her hand up at the beginning. I don't know if Terry's still on. I wanted to just give her the opportunity to ask her question if she wanted to. Yeah, Terry's there. Terry, do you want to ask your question?
Yes, please. Good evening.
Hi. Yes.
I'm not certain that Mrs. Bethel answered the question just now, because I think internet was going in and out, but it might be a similar question that I have. I just wanted to know the good reason why an insurance company would require an insurance policy holder, a life insurance policy holder, to inform the beneficiary, say beneficiary A, that you would like beneficiary A to be changed or either share between beneficiary A and beneficiary B. What is the good reason for informing beneficiary when they in the first place may not even know that they're the beneficiary? And I'm not talking about spouse, I'm talking about perhaps children of 18 years or older.
What's that? That's for me?
Yeah, I think that's for you, Shannelle.
Yeah. Well, the concept between spouses in particular would be kind of, you've created a contractual promise. You've promised that in the event of your death, this is what I would like to happen. And so there are a lot of rules that apply as between spouses because you've relied on that. You generally would be deemed to be dependent. The surviving spouse would generally be deemed to be dependent on the deceased spouse to some extent, and that where that promise has been made, you ought not to unilaterally be able to pull out of that. Now, as it relates to children, once again, it's the concept of being a dependent. But if that child obviously is under the age of 18, they would not be able to sign. So it would be where you would have placed that child on there after the age of 18 for that purpose. Whether or not that's deemed to be a great reason why they ought to consent, I guess that's probably a matter of opinion. But the basis in law of it is dependency.
Yeah, I just want to add to what Shannelle said. You know, there's also a piece of legislation called the Married Women's Property Act, essentially where an irrevocable trust is created as between spouses. And so if you, by law, essentially, this is in the legislation, Married Women's Property Act, and I think it's in the Insurance Act as well. So the law actually says that you cannot, if you have named your spouse in your insurance policy. You can't change that without their consent. Now, of course, I don't think it's the same thing in that sense.
I understand that.
Yes.
I'm not speaking about a spouse. I'm speaking
Okay.
about other people, you know, children or other family members.
Right. Well, I mean, that I think it will then go back perhaps to a contractual position, which is what Shannelle was getting at. From an insurance standpoint. I don't know, perhaps Cleora or Claudia may have some comments there in connection with that. But I think if it's anybody other than the spouse, you should be able to change the insurance contract. I know for spouses, you can't without their consent.
No.
Right. Did
Claudia,
the person sign? Yeah, because we see some of these questions with insurance policies through Helena, but did the person who's the beneficiary sign the policy or not?
No, ma'am.
No? Okay. So then you would need to read the fine print of that particular contract. There may be a reason, but usually only if the beneficiary signs to say they acknowledge this contract, right, then they would be notified. But usually I'm thinking it's something in the fine print of that contract.
I see. Okay, thank you.
Okay, so there are a couple of other questions here that seem to be surrounding wills, but I'm going to go to Claudia. There was a question here specifically for Claudia. What is the fee assessed on having a portfolio with CFAL? And what is the criteria for enrollment? And do you have to invest monthly in mutual funds? I guess that's if you are accepted as a client. I don't know, Claudia, can you maybe speak to that, please?
Sure. So our standard enrollment requirements are our application form, a copy of your passport, an NID card or driver's license, and a current proof of address, such as the purple voter's card once it's your current address, or a utility bill within the last 6 months with your name and physical address on it. So once all of that is complete and we review it, then you are good to go with making your transaction at, any online transfer. You can go into the bank and make your deposit. And the second part of that question was, do you have to make monthly payments? No, it is not a requirement, but we encourage it. If you're using it as a savings program, we encourage you to make monthly, or, some entrepreneurs go by contracts. A lot of contractors, they may have a large job, and when they get paid out, they would do a lump sum payment. That is also okay. You get a bonus from your employment. You can make a lump sum deposit. It's not mandatory you do monthly, but so we have clients who do both. So those are the requirements. I don't know if there was anything else that I missed.
No, I think that was it. I think that was it on that question. So thank you for that, Claudia. Shannelle, this one is directed to you. They said a husband dies without a will. He has several children, but one of them is not biologically his. And I think at the time that he signed for the child, he wasn't aware that the child was not biologically his. I think this is how I was reading that question. Is the child entitled to anything at his death?
Right. So if the father signed, the presumption at law is that he is in fact the father. So the real question comes down to whether or not there's someone that's contesting that and has proof and evidence that he in fact was not a child of the deceased person. I've never actually had an instance that works like that. It's usually in the opposite direction, where the child was not signed for, but was acknowledged as a child. But most certainly in an instance such as that, it would be a matter for the courts and for the courts to determine that that child was posthumously was not, in fact, a child of the deceased. It would be interesting to see what type of evidence they would have to produce to prove that. And I would venture to say it would have to be quite strong in the sense that there must be some sort of blood tests or anything like that, which may be very difficult to establish post-death. But yeah, that is likely to be a difficult one to get over the line.
Okay, thank you. Thank you so much for that, Shannelle. There is another question here. It says, can you provide some advice, Shannelle, on, this is for you again, some advice on choosing an well, I think they meant an executor of a will, right? The cost of preparing a will, does it have to be registered? Can you amend? And I think the last part of it was, is there any cost to amend?
Right. So one of the first things that you want to do is choose an executor that has some financial acumen, because this is the person who will be empowered to do whatever you would have been able to do with your assets and with your funds had you still been alive. So they will have access to cash, they will have access to sell properties. Obviously, it will be within the confines of the devises and the gifts that you have set out in your will. But nonetheless, you want that to be someone who is responsible financially and has some idea on how to deal with assets that may not have been specifically devised, or with any trust provisions that may come into play if you have, for example, minor children and you've established testamentary trusts. So that's the first thing. And you want it to be someone also, obviously, that you trust to carry out your wishes, but not just carry out your wishes, but to do it in a timely fashion. One of the biggest problems we find with estates are that after the person passes away, the person who is named the executor kind of, either out of an ignorance of not knowing what the next step is, or just not wanting to be bothered, they just kind of slow walk getting the probate done. You have assets that may lay waste as a result of that. And beneficiaries who obviously ought to have received the benefit of those assets much sooner than they have in fact done so. Typically, an executor should probate the will and distribute the estate within what we call an executor's year, which is 12 months after the death of the deceased. So where you find that is not happening, the law provides certain actions that you can take as a beneficiary in order to kind of prod them along. The general cost of preparing a will, I mean, it's very wide ranging, but if you're referring to a basic will, and when we say basic, it's kind of like I leave my house to my husband, my cash to my kids, probably a few clauses that don't include testamentary trusts, don't include guardianship provisions. You're probably looking at a cost of about $450 or so. You can amend the will at any time that you see fit. If you change your mind every 5 days, you can go in and you can change your will. That can be done by way of a codicil. It could be done by way of destroying your previous will and making a new testamentary paper or will with respect to your assets. Just bearing in mind that even if you do a codicil, which is a document which amends an existing last will and testament, that it must follow the same protocols and have the same execution logistics carried out. 2 witnesses, must be of sound mind, and all of those things must apply to every codicil that you do. And you can have multiple codicils that amend your initial will. The cost for the codicils, once again, that varies, but I would say you probably should estimate around about $250 to $350 for the codicil. If you have a more complicated will, for example, you would find that wills are much more involved when you have persons who have wide-ranging assets, minor children, businesses that are going concerns where they need to actually put quite a bit more into play to make sure that those are dealt with appropriately. You can easily get into a $1,500 price range or even more.
Okay, thank you. Thank you, Shannelle. I think Samantha would, I'm going to ask if you would unmute, allow, if somebody raises their hand, our administrator, please allow them to make their question. Samantha Wood she had her hand up for a little while. I'd like to hear what her question is, please. Administrator, please let Samantha Wood, I think we should unmute the,
Hello.
yes, great, thank you.
Hi, thank you very much. I have a question. What if a lady has been married? She has children with her spouse, and the spouse has now been deceased. If she was to remarry without a will, would that new person be able to receive her assets if she was to pass?
Yes, the answer is yes. If she dies now without a will, then that spouse would be entitled to 50% of everything that she owned at the time of her death. And this is where the contractual wills are great, obviously, because, when this comes up between spouses, sometimes you have a spouse that says, well, I don't want you to tie me in contractually. Suppose you pass away and then I have a new wife. These are the things that you have to consider. Obviously, when you have blended families where a spouse passes away, someone remarries, they now have children-in-law and their own biological children, you want to be responsible about making your will to make sure that, your biological children, if they were intended to receive certain assets that were the product of your prior marriage, that they in fact do receive those assets, so that the intent of your deceased spouse still to some extent can be carried out.
Thank you, Shannelle. There was a question here, and says, can an executor be a beneficiary? And I think that's directed at you again. Can an executor be a beneficiary? And yeah.
Yeah, so an executor can be a beneficiary. They just cannot be a witness to the will itself. So yeah, I mean, that's the short answer.
Yeah. And the reality is that usually more often than not, the executor is either your spouse sometimes, or it's one of your children. And those are the people that actually benefit under the will, but clearly they're the ones that you trust. So that's the way that the law is structured. That person can't be a witness because you don't want any undue influence. But of course, an executor can be a beneficiary. So most of us are beneficiaries, for example, of our parents' wills. And of course, we stand to benefit under those wills as well. There's a couple of questions here. They say, why does a will have to be probated if it is left to a child, say a daughter? I mean, this is a general question. Why is it that wills are probated, Shannelle?
Wills are probated so that the court can, one, ensure that the will was in fact executed with the usual formalities, and that it is in fact a valid will. So it's a recognition by the court that the will is in fact valid for the purposes of giving effect to the gifts and devises that are contained in that, and for giving, by the court giving that grant of probate. A grant of probate or letters of administration, whatever it is equivalent to any court order that may be granted in any court case. And so that's now an order of the court that can be recognized by any person or entity as being a recognition of that will, as well as evidence of the power of the person in whose name it's made to deal with those assets without there being any fear of doing something and then it be found that you were not dealing with the correct person, in respect of those assets. So inherently, by virtue of that court order or grant of probate, there's a protection by law that's also granted to anyone who then deals with assets flowing from that estate that are passed along by that executor, so that they can say that I've relied on this grant of probate, which at the time that I did what I did, it was not revoked by the court. And so that's the reason why a will has to be probated.
Thank you. Thank you for that, Shannelle. There's another interesting question they said here that says, how does a court rule? I don't know if you know how the court would rule, Shannelle, but they said, how does a court rule in the case where a husband and wife have separated for 10 years, the husband dies without a will, or they were living, these two people were living together as common law spouses, and one dies intestate? What would be the entitlement of the other person, the survivor?
So we don't recognize that in the laws of intestacy. So you would need to be legally married if you want to benefit by virtue of the laws of intestacy as a spouse. That's the second part of the question. I think, the first part is talking about being separated for 10 years and the husband dies once again. If you haven't left a will and you were still legally married to that person, that would still be the person who has the first right to apply for a grant of letters of administration in your estate, and they would still be entitled to their share. So you would need to ensure in that instance, if you are not legally divorced and you don't intend to go ahead and do that and just remain separated, that you ensure that you have a will to protect your common law spouse, or to protect your assets from a spouse that you may have been separated from, by providing for those assets to go to someone else under a will.
Okay, thank you. Okay, I'm going to jump to an investment question. I see here that says, what is the view on Bitcoin as a form of investment? Cleora?
Good night. Bitcoin to me is at this point, is very volatile. There's some Bitcoins that are asset-based and there's some that are not. I think it's very much in the learning phase and what people are doing with it. I think it's going to be around for a while, despite the fact of its volatility, because a lot of it's going to be used now for things like, record management, they're using it to help with a lot of the businesses. That aspect of it is going to continue. But in the present time, I think it's very volatile. So I think what person should do, if you're going to do it, first and foremost, that money should be monies that you don't really, investing always should be monies that you can kind of afford to lose. And what I recommend what you do is, make sure you do a lot of research and, come speak to us and more specifically in terms of if you want to invest. Currently in the Bahamas, there's no one offering it. I know FTX, one of my clients, is saying that they are currently working on their platform so that Bahamians are able to invest in the Bitcoin. But at this time, I'm not aware of any other than that.
Okay, was there anything else on that? Pastor, was there anything else on that?
No, that's great.
Okay. Okay, Cleora, there was another question here that says, how much should a 45-year-old woman invest into her retirement with an estimated 14 years left at her current employment?
Well, of course, it's firstly going to depend on, like I said, what it is that you want to do in retirement. I mean, I could say I can give a figure out there, but what you're going to have to do is you're going to have to get an analysis on your income and your expenses and what your expenses are going to be in retirement. And once you come up with that figure, And then we're going to figure out, how to get to that figure. So for instance, if it's $100,000 that you're going to need, or 300,000, then we work backwards. And that could be, if it's 14 years, you might have to put 300 a month, you might have to put 400 or 500 a month. But the idea is we have to sit down and do an analysis with you to see how much it is that what your income sources will be in retirement, what your expenses are. And of course, we're going to reduce your expenses as much because your income is fixed. And once we come up with that figure, then we work backwards to see how we can, get to that amount for you.
Okay, thank you. Thanks for that, Cleora. Yeah, I'm seeing a question here. What happens in the event that a beneficiary of your will passes away? So they die, Shannelle, prior to your death, and you didn't have time to revise the will.
So if someone passes away prior to your death, generally there would be a lapse of the gift, unless that person was in fact one of your children. So if it was a child of the deceased and that child predeceased the parent, when that parent passes, anything that was left in the will to that deceased child now passes along to that deceased child's children if they had children at that time. So, and it would be shared, what we call per stirpes. So if I as a mother left property to two of my children, one predeceased me, then, and at the time that they predeceased, they left children, then those children would share my 50%. The other child would still get their 50%.
Okay, great. Thanks, Shannelle. Now this particular question, I think here they're getting at from Denise folks. Is it safer to put the person's name on the item you want to leave for them and don't have a will at all? So essentially they're saying, should I just, convey or transfer whatever I want to give to a child or a person during, lifetime, as opposed to leaving it in a will?
Well, this really just comes down to what your financial what's the state of your financial affairs. I'm sure Claudia and Claudia would agree with me on this. If you can afford to kind of give up a bit of your control over certain assets because you may not need those. For example, if you own a home and you want to leave that home to your children, now would be a great time to put your children's name on that asset if they're over the age of 18, because there's some exemptions that you can get and you don't have to pay VAT on the transfers. However, if you do that, then anything you would like to do with that home during your lifetime, you have to have the agreement of the persons that you have put on that property. So if you find yourself in a situation where you need to mortgage that home, they would have to agree to the mortgage of the home. If you want to sell the home, they would have to agree to sell the home. And if they don't, then that could kind of put a bit of a wrench in your own plans, or whether they be financial or otherwise. So I would just say that you want to have an idea of what your financial capacity is, as well as what's your appetite for being curtailed in the event that the persons who you put on those assets may not agree with the way in which you're handling those assets.
Okay, great. I think that Victoria Forbes had a question. She had wanted her mic unmuted at some point. I'm gonna, could you please let Vicky say whatever her question is or comment? Victoria, you have access yet? Okay, while we're waiting for the administrator to give her, to unmute her mic, then
Hi, Tanya.
Yeah, okay.
Finally got it in. I think one or two of them you would have addressed, but I'm concerned with the cost of, well, two things. I think maybe not getting them probably attached. The returns that was quoted, I think by Mrs. Cleora, I'm not sure, I could be mistaken, about the returns of 6, 8, and 10%. I'm very interested to know which investment category is going to be yielding those kind of returns, even with inflation. And I also think, there's another question that was asked about, the cost, which I think is a Ms. Thompson question about creating a portfolio, so you would have the average Joe Blow that has his or her job. And you're telling us now, and particularly with central bank now diversifying it to brokerage houses, what would be the cost of, so I take my 4 or 5 IPOs that I invested in originally. So if I wanted to buy more stocks or more of anything else, I'd have to go through a Fidelity or a Kalina. What kind of costs are we looking at for the regular Joe Blow? Because we already have a challenge with savings. So you're looking at me having to come up with what every month to maintain this portfolio of a few assets that I have. So 2 different questions, 2 different people.
So I'll start first in terms of the returns. Our mutual funds are actually performing very well. Our balanced fund has done over the last 3 years about average 8%, and our equity fund has averaged around 12%. It's actually even higher last year. So they're performing extremely well. So those returns that were quoted, we actually are, despite inflation, our portfolios, our funds are actually generating those types of returns.
Okay. So with the return from CFAL, we have, like I was saying, low risk, moderate risk, and high risk. So when you talk about higher returns, usually you're taking a little bit more risk, not always, but a lot of times. So with the low risk mutual funds, we've usually seen around the 4% each year. Then we have moderate risk that's a mix of like stocks and bonds that can get up to 7-8%. And then we have global funds. We have USD funds that have seen up to like 12% returns each year, but those are considered high risk in some cases and in moderate risk. So you have to be okay. We always say we want you to sleep at night. So you have to be able to see some negatives on your statement some months and then positives other times, with the idea being over the long term, you will see a higher rate of return. And with, you were asking about fees. So if you register with us, you will have to pay, like if you do a private wealth or brokerage account, we start with $50,000 in cash or securities, and that comes with a minimum of fees of $350 per year. But we also offer one-time trade services that are based on the volume that you're going to do. So that is much lower. So you would just call our brokerage department and they would give you a quote based on what you want to do for a one-time trade.
Okay. Vicky, you good? Okay. So we have a question here. It says, oops, get to it. All right. Is it advisable to put real estate investment property in a passive holding company owned by a married couple and have children added to the company as they become of age? And I think this it says will a will be needed, right? So I guess it's primarily directed at Shannelle, but Cleora or Claudia may want to weigh in as well.
So yes, you can put property in a passive company, and really you would be doing that. Usually you see that primarily because they want to have some form of asset protection. In a lot of professions, persons may be exposed personally where they are, for example, lawyers, where we're not generally allowed to incorporate companies. We carry out our services on a personal basis. And so to protect personal assets in the event of some instance, whether that be a car accident, anything, you put those assets in a different vehicle, like a company, so that it is segregated from that type of liability or exposure. And yes, you can put your children on that company as they come of age. What you want to be careful of is the type of company that you put it in. There are certain types of companies that can be, the memorandum and articles of association can be drafted in such a way that they operate a bit more like a trust, or sort of like hybrid between a company and a trust, whereby you can provide for classes of beneficiaries or classes of shareholders, I should say, under that company that become shareholders on the death of someone else. So I would definitely recommend, if you're interested in doing some of that, to go talk to Tanya. I'm sure they've done that more than a few times. And then, yes, it means that in the event that, for example, a Class A shareholder passes away, then those shares transfer over to a Class B shareholder that may be your children, and that assists with not only asset protection, but estate planning as well. Tanya, there was a second part of that question. I didn't see it in the actual.
Yeah, that was a diagram. Let me see if I can find it. I'm looking for it again. Oh, yeah, and would a will still be needed? That was the second part of it. It was, so it was just, yeah.
Right, so a will would not be needed depending on how that company is structured. Generally, if you put something in a company and you have standard mems and arts and shares are issued and you are the owner of those shares, solely the owner of those shares, then you will still need probate for the purposes of having those shares transferred over to whomever you left it to in your will. You can have share certificates that are joint with right of survivorship, and you can put everybody's name on it. And then if you pass away, you produce probate, and then you're no longer owner of those shares and the remaining shareholders own that. But once again, you want to be careful because it places a certain level of control, or you're giving up a certain level of control over that asset and sharing it with everyone else that you've put on there, as opposed to protecting the asset and providing for someone who will get that asset on your passing, thereby keeping you in control of your assets during your lifetime.
Okay, great, thank you. Cleora, this question is for Cleora. Does Fidelity offer Bahamian trusts? I guess the question is, do you act as trustee of Bahamian trusts?
Yes, we do. We have a trust license by the central bank, and we do offer trust to Bahamians.
Okay. All right. Shannelle, what advice would you give to siblings who are not communicating effectively and the estate has to be probated?
Fun times. I would recommend they all go and see a lawyer. And the reason I say that is I find frequently that people don't generally understand what the process is. They don't understand their rights. They don't understand the role of a person who's administering an estate as opposed to the role of a beneficiary, as well as the other moving parts and logistics that go into probating that estate and getting the assets from the estate to the beneficiary. And they frequently don't understand the loss to them as beneficiaries by the fluctuation of time and the delay that comes about inherently because people are not communicating. So my recommendation would be, as opposed to divide and conquer and everyone go and get their separate lawyers or not do anything at all, that there's a recommendation that they all go and see one single lawyer, that they can sit down in a room. And if they already have separate lawyers, my recommendation would be is get all of the lawyers in that room with all of the beneficiaries, because the law is the law. And once you're able to sit there, and sometimes I've found with siblings that don't get along, that once they're in a room and they're able to voice their questions, that everyone else can hear and everyone can hear what the true answer to that question is and understand, it removes some of the personal angst from it. Because they're getting sort of an independent view and independent advice on how to move the matter forward. And usually that's where you begin to see some movement.
Yeah. And then, of course, like you said, Shannelle, actually going to a lawyer that's completely independent of anything to do with any particular child. One of the children may have their particular lawyer and somebody else has their lawyer. If you can go to somebody that everybody considers to be neutral, you might actually make some progress.
Yes.
Okay, there's a question here. If a man dies without a will and he and his wife never lived in his house with his first wife who died, right? So then he got married again. And he has a second wife and never lived, and his second wife never lived in the house. because she had her own house. Then and they actually didn't live together up to the time of his death. And he has children over 18 from his first marriage, and older children. I guess the question is the way that I is a bit convoluted, but I think what they're saying is that there was this house, there's a house there. And I guess nobody got the chance to actually live in this house. The husband and the first wife never lived in the house. Then the second, when he got married to the second wife, it appears to me that neither of them, he ended up living with the second wife in her house. Mm-hmm. So the question now is, okay, the children, his children, are they entitled to that house? Are they entitled to that house, or what should happen to the house? But yes, they do say the man died without a will.
Mm-hmm. Right. So the short answer to this is the children would be entitled to 50% if one spouse is still alive, which I think based on the question, it appears so. If he died with a wife still living, then 50% of his assets go to the wife, and the other 50% go to all of his children, whether born within a marriage or not. So it wouldn't, to my mind, a matrimonial home would not come into play with this. And that would affect all of his assets. So it would just be a 50-50 split down the middle.
Okay. Okay, we're gonna wrap up. The questions are still coming in. So there are about 2 or 3 more questions, and then we're gonna wrap up. Do I automatically become the executrix of a will that my spouse was executor of when he died?
No.
Or do when he dies? Yeah.
Yeah. So what we're talking about is a chain of executorship. So if I am the executor of someone's will and I then have a will of my own and I appoint an executor and then I pass away and for some reason I didn't complete the administration or there's something else that needs to be done in the estate, which I was the executor of, then because of the chain of executorship, the person who I appointed executor of my will would then be able to go back to the court and say, well, I'm the executor of this will. This person was the executor of this other person's will. And so I am now entitled to get a grant, de bonis non is what it's called, for the purposes of, in that other person's estate, for the purposes of completing the administration or carrying out some other task in that other person's estate. Okay. So it wouldn't be automatic. You have to make an application and prove the chain of executorship is unbroken.
Okay. I'm going to jump to a question and then I'll come back up to a question from Michelle Stubbs. It says, hearing that NIB will soon be depleted, is there anything in the works to make contributory pension fund mandatory for companies? I guess pension funds mandatory for companies. So Cleora and Claudia, I don't know if you all know anything about this.
Great question. Pension legislations have been in the books in the Bahamas from about 20-30 years now, but it's never been enacted. We would love to see some type of mandatory legislation come into the country because at the end of the day, like I said, a lot of persons are dependent on NIB and it was never created to be a primary source of retirement income. It's only supposed to be supplemental. And with the fact, added to the fact that our savings rate is so low, it's, almost like the perfect storm for when persons are retiring. They just don't have enough funds. But now is the time with the new government. I think it's time for you to, the best thing to do is to agitate to your politicians for some type of mandatory legislation.
Absolutely. Claudia, did you want to say anything on that?
No, I agree. The legislation has been drafted and, redrafted and it's there, but it's never been enacted. And we, I'm sure both investment houses would be very happy if it was enacted because we see all of the clients who need it and are thinking they're depending on NIB and it's just not going to happen. So I think we need to make sure it does happen and it's a law so that our people have something to look forward to when they retire.
I think we put so many things ahead of that. I think it's been a low priority item for so many years. And so I agree with both of you that we need to agitate for the enactment of legislation that makes pension funds mandatory. Okay, it says Michelle's question was, can a parent will property to one child on the death of the other parent and exclude other lawful children? So Shannelle, I think this is for you. Can a parent will property to one child? So this is that the spouse is dead. And then they're essentially giving everything to a particular child and excluding the others.
Yeah, you can do that. I mean, in the will, you can leave your assets to whomever you wish to leave them to. Where the exclusion may be problematic is if any of those children that you've excluded are dependents at the time of your death. Dependents as it relates to education, where they're over 18, or dependents as it relates to disability, or dependents where they're under the age of 18, because the court has the inherent power to reapportion your estate to ensure that anyone that is in fact a dependent would still benefit. So you want to be careful about excluding dependent children when you're doing something like that.
Okay, thank you, Shannelle. Okay, we're gonna wind down in a second. Denise Woodside says, if the wife dies, leaving 2 adult children and 2 minor children, husband got married, what happens to the assets obtained in the first marriage? He was advised to make a will after marrying the second wife. So it says, if the wife dies, leaving 2 adult and 2 minor children, so she's gone. The husband then gets remarried. What happens to the assets obtained in the first marriage? So I guess between the 2 of them, and he was advised to make a will after marrying the second wife.
Yeah. So if she died without a will, her husband or her surviving spouse would have become entitled to 50% of her assets, and the adult and minor children would have been entitled to the other 50%. Presumably what will happen is the 50% that the 25% that the minor children are entitled to would likely be given to the father as the guardian of those 2 minor children. So he would have the control of those assets to be held on trust and used for their maintenance and upkeep on general trust, general trust law. The older 2, the children that are over 18, they would be entitled to receive their share once the estate has been duly probated. And if the first wife and the husband shared a matrimonial home, then he would be entitled to stay in that home for the rest of his life until he remarries. So since once he's remarried, he has to move out of the matrimonial home if there was one, and then that home would be split between them, which in most cases would mean it would need to be sold. And that's obviously predicated on the basis that the home was not in their names jointly, such that he became the sole owner on her death.
Right. Thank you. Thank you, Shannelle, for that. I think this is the very last question. How is it possible if the second wife had her own house, so the children of the first wife get 50% of her assets? I mean, these are all questions surrounding.
The second, you can't get 50% of the second wife's property unless she dies unless first of all she's deceased. Second, that you are a child, one of her children, such that you could inherit on intestacy. So if you are a child of the first mother that passed away, then you're only entitled to assets from that estate or assets from your father's estate. It's a familial connection. But you wouldn't be entitled to the second wife's assets unless by will she leaves them to you. Or if you're legally adopted by her, then you can be entitled if she dies on intestacy.
Okay, excellent. All right, so I want to say, I think that's it. We've gone for quite a while. So I want to say a really very, very special thank you to our three presenters, Shannelle, Bethel, Claudia Thompson, and Cleora Farquharson. And I wanted just let them know how very enlightened I think we all are because of the presentations that you made this evening. And I'm sure that everybody would join me in saying thanks. There are a number of people that said they want to get your contact numbers. So what we'll do is we will make that available. We'll make the contact numbers available. I'm trying to think how to do that now at this point. But yes, anyway, we have Miss Bethel, Mrs. Bethel, Mrs. Thompson, Ms. Farquharson. Thank you so very much. I want to let you know, I really appreciate it from the bottom of my heart. I know that, at the end of the day, you have a lot of things going on. And so the fact that you are here, you've taken, 2 hours out of your time. And then, at the end of the day, it doesn't just begin at 6 o'clock. I know you all were preparing prior to this. So thank you very, very much. And I just wanted to know, is the pastor still on? Pastor, did you want to just say something very quickly and maybe just give us a closing prayer, just so that the this whole presentation, the seminar was recorded, and the presenters will make their presentations available. We'll put it on the church's website, Centerville Seventh-day Adventist Church, on our website. So the information will be there. And to the extent that I'm able to assist in connecting you with any of the people, my contact number would be 376-1762. And I am at trh@gtclaw.com.